Hello, my dear students. I am Professor Muhammad Masood Ahmad. Welcome to the legal classes. And today's topic is the Supreme Court at Calcutta. It is composition, power and functions, and failure of court. Act of 1781. Supreme Court, Mufassil Court. So these topics are there in a law subject called History of Courts, Legislatures, and Legal Profession in India. So this topic and this subject is there in LLB, affiliated to Osmania University and most of the universities in India. So let us go for the first slide. The Supreme Court of Judicature at Fort William in Calcutta was founded in 1774 by the Regulating Act of 1773. It replaced the Mayor's Court of Calcutta and was British India's highest court from 1774 until 1862. See, Warren Hastings, he had the judicial reforms and he introduced the legal system in India, and he had the various hierarchy of courts, including the Mayor's Court. But after few years only, I think they found the necessity of having a Supreme Court, which was established in Calcutta. So when the High Court of Calcutta was established by the Indian High Court of Act 1861, so it was functional right from 1774 to 1862, because there is a Indian High Court Act. It came into force in 1861. Let's go to the other point. Sir Ilja MP, Regulating Act 1773, Establishment of Supreme Court of Justice, Section 13 of Regulating Act had empowered the Crown to establish a Supreme Court of Judicature at Fort William in Calcutta. It was presided over by the first Chief Justice, Sir Ilja MP. On March 26, 1774, a Charter of Justice was granted for the establishment of Supreme Court at Calcutta, King George III. The Supreme Court was established on 22nd October 1774 and began functioning in January 1775. It is the first attempt in creating a separate and independent judicial system in India. So this is the beginning of Supreme Court. So it was in the beginning of 1775. Then civil jurisdiction under the Charter of 1774. The court was given original jurisdiction in civil matters, which extended to the following: East India Company, what is covered? Jurisdiction, the coverage. It is East India Company, Her Majesty's subjects, British people living in Bengal, Bihar, and Orissa, any other person who directly or indirectly comes into the services of the company, that is the East India Company. E. Residents of Bengal, Bihar, and Orissa. These cases could be heard if they had consented in writing to refer their dispute to the Supreme Court, provided the subject matter of the suit exceeds rupees 5,000. So this is the coverage, and what type of cases are covered. It is mentioned, it is the civil jurisdiction, and the what is covered: the East India Company, Her Majesty subject, British people living in Bengal, Bihar, and Orissa, the residents of Bengal, Bihar, and Orissa, and the value which is more than 500 rupees that time, because it's more than 200 years ago. So 500 that time is a big amount. Criminal jurisdiction, Charter of 1774. The Supreme Court in the matter of criminal matters was constituted as the court of oyer and terminer and target distribution as the city of Calcutta. Fort William and factory subordinate to the factories to hear the criminal cases of British subject. The Supreme Court appointed grand jury and petty jury. Its jurisdiction extends to Her Majesty's subject and employees of the company, but the Supreme Court did not have the jurisdiction native to Calcutta and the regions of Bengal, Bihar, and Orissa. Governor General and Council for any offence except treason or felony. Then the next bullet point, the Governor General, councillors and judges of the Supreme Court acted as a justice of peace and held quarterly sessions. The Supreme Court was empowered to suspended annual or suspended any death sentence if it was a case fit for mercy, but it would be referred to the British Crown with the reasons for the final decision. So this is the criminal jurisdiction. The important thing that in case of capital punishment, the death sentence, so it can have the appeals because it is the highest court. This is the Supreme Court, provided are subject to the approval and referring to the British Crown with the reasons for the final decision. The final decision, it is with the British Crown. Then Admiralty Jurisdiction, Charter of 1774. The Charter of 1774 declared the Supreme Court to be the court of Admiralty for the territories of Bengal, Bihar, Orissa. It can try all civil and maritime matters and offences committed thereon, consisting of British subjects residing in Calcutta with the help of vessels, ships, ferries, and high seas, and offensive juries from Bengal, Bihar, offshore juries from the Bengal, Bihar, and Orissa. This jurisdiction was extended to His Majesty's subject and direct and indirect employees of company residing in Calcutta and the territories of Bengal, Bihar, and Orissa. So this is the background of Admiralty Jurisdiction Charter of 1774. So consisting of British subjects residing in Calcutta with the help of vessels, ships, and ferries, and high seas offshore juries from the Bengal, Bihar, and Orissa. So this is the jurisdiction. And Ecclesiastical Jurisdiction Charter of 1774. Ecclesiastical. Ecclesiastical has got a meaning in the theology and in spirituality. The Supreme Court exercised the church jurisdiction over British subject in Bengal, Bihar, and Orissa in the same way as it exercised in the Diocese of London. It provides probate of the will to the British subject and letters of administration for property and other influences of British. It also included people who died within the areas of Bengal, Bihar, and Orissa. So this is the religious activities, the religious functioning. So that the meaning is it is the court exercise, the church jurisdiction. So it deals with the religious practices, performance, and their functioning. So those type of cases are also deal in Charter 1774. Equity Jurisdiction Charter of 1774. The Charter of 1774 declared the Supreme Court of Justice as the court of equity. it was empowered to do justice according to the rules and proceedings of the court, Chancery of England. The Court of Chancery in England administers justice according to the principle of justice, equality, and good consciences. So this is the background for the equity jurisdiction. So equity jurisdiction, it was also there in the legal system in England, UK. The same thing brought here for the Supreme Court under the Charter of 1774. Writ jurisdiction, Charter of 1774, as in the modern days we see, if it is a writ, it is provided by the Indian Constitution. Either individual, citizen of India, he can go for, so either the High Court and the Supreme Court for the writ. So that time in the Charter 1774, the Supreme Court, being a Supreme Court, can issue certiorari, mandamus, error, or writs of procedure to the collector's court, a court of request, quarterly sessions, and sheriff, etc. See, when we go for the subject called Indian Constitution, there the particular articles are there where the Constitution guarantees to file the writ either in High Court and Supreme Court for a particular reason and purpose. There are few conditions. So this writ was introduced even in the Charter of 1774. It's almost 200 years ago and more than that. Then provision for appeal, Charters of 1774, how the appeal is made. In civil matters, an appeal from a Supreme Court decision could be taken to a king in council in England only if the subject matter of the dispute exceeds the 1,000 pagodos. Appeals must be filed within 6 months of the decision. In criminal cases, the Supreme Court enjoys the absolute discretion to allow or deny an appeal to the king in council. Further, the king in council reserves the right to reject or accept the appeal as a special case on such terms and condition as it may deem fit. So any appeal, if any judgment from the Supreme Court, if you want to go for the appeal, that is also possible, but that you have to bring it to the king in council in England, but subject to the approval and permission of the Supreme Court. And king in council in England, they have got the right to accept it or reject that particular appeal. So this is the provision of appeal. The Supreme Court at Calcutta, composition and function. The Regulating Act of 1773 established a Supreme Court at Fort William, Calcutta. This Supreme Court consisted of one Chief Justice and three other regular judges or puisne judges. Puisne judges, no, they are not the senior judges. They have got the less standing as a judge. The letters of patent was issued on 26 March 1774 to establish the Supreme Court of Judicature at Calcutta as a court of record with full power and authority to hear and determine all complaints for any crimes and also to pay the entertainment here and determine any suit or action against any of His Majesty's subject. So Supreme Court at Calcutta, it has got the composition of judges, the senior judges and regular judges. So the consist of it is the Chief Justice and three other regular judges and puisne judges. Puisne judges is the junior judges. So this is the composition of Supreme Court. Then Act of Settlement 1781. The main purpose of the Act Settlement 1781 was to establish a system of court to remove grievances against the Supreme Court and mitigate the failures of Regulating Acts 1773. So whatever difficulties and failures we had in 1773 Act, Supreme Court Act, that we had the issue of settlement here. The Act of Settlement 1781 was an amendment act which removed the shortcomings of the Regulating Act 1773 passed by the British Parliament on 5th July. It is also known as the Declaratory Act of 1781. Uh, Declar Declaratory Act 1781 is known as the Act of Settlement. The purpose of the Act was to remove ambiguity, the confusion and the vacuum we have in the interpretation of the Act regarding the provision of the Regulating Act. The Act of Settlement was also implemented to ensure a smooth collection of revenue in Bengal, Bihar, and Orissa. If you see the beginning of the Britishers, that is the year 1600, when they have established the East India Company, that was established on 31st December 1600, and it is operational from 1st January 2000, 1601. So right from the beginning, I think now we are talking about Act of Settlement 1781, means almost it is say it is 181 years it is happened when we have started the East India Company. The Britishers started the East India Company in India. But if we see right from the beginning and now, 1600 to 1781, directly and indirectly, when the Britishers, they establishing the judicial system and the legal system in India, and they wanted to have the control of territory and the control of administration. So, but directly and indirectly, they were concerned with the generating the revenue, the collection or boosting of the revenue, how to collect it, and we have to remove all the barriers and difficulties in collecting revenue, because the revenue for any country and any ruler, so it is the core resource for running the country and nation. So this is the background. So thank you, students, that it is all the best for you, and we'll be meeting in the next session regarding this subject called History of Court, Legislature, and Legal Profession in India. Thank you. All the best.